Hello, everyone. It's my pleasure to work with the Vermont SBDC to offer you this program today. And I am thrilled to introduce our panelists. The Honorable Judge Colleen Brown, Chief United States Bankruptcy Judge for the District of Vermont, Alexandra Edelman, Attorney at Law at Piper, PRIMMER, EGGLESTON, and CRAMER, PC, and co-chair of the Vermont Bar Association Bankruptcy Section, Professor and Attorney Don Hayes, professor at Vermont Law School and co-chair of the Vermont Bar Association Bankruptcy Section. As Linda Rossi mentioned, I will be taking the questions and I will present them to the panelists at the end of the first presentation, at the end of the PowerPoint. I will also be posting into the chat for you to download the PowerPoint and a PDF document that the panelists will be referring to in the second half of the presentation. So please look for that in your chat. Where you will be able to download that. And without further ado, I will turn this over to Judge Brown.
Thank you. Good afternoon. My name is Colleen Brown and I serve as the U.S. Bankruptcy Judge for the District of Vermont. It's interesting to know in Vermont we have just one bankruptcy judge, and I've been in this position for just over 20 years. It's my honor to talk with you today about the reorganization and restructuring options that are available under the Bankruptcy Code. And they are available for all types of small business and in pretty much all types of circumstances. And I want to say up front that by no means are my co-presenters and I suggesting that every small business should file for a reorganization under the Bankruptcy Code, nor that a reorganization is right for every business or can solve every challenge a small business encounters. It is, however, a potent and versatile tool that small businesses should know about. And as a result of legislation that went into effect last February, which is specifically for small business reorganization, I think the word is getting out about how effective bankruptcy can be when a small business needs to either restructure its finances or its operations to become more viable. And we want to talk about these various types of restructuring and reorganization that are available. And it will be up to you to determine how pertinent they might be to you. Before we dive into the details, I'd like to take a few minutes to give you what I call a big picture lay of the land. First of all, it's important to know that whenever a bankruptcy case is filed, all collection activity against that business must stop. An automatic stay goes into effect. This allows the business to continue its operations, but also to focus on the reorganization. In sum, the filing actually creates more predictability and a sense of calm and focus for everyone involved. The rules of the game change when a bankruptcy reorganization is filed, but everyone knows and follows the rules. And that's what really creates the predictability that I think can be very valuable. It's also important to bear in mind that a successful reorganization benefits not only the business or debtor, but also all of the creditors. If the reorganization is successful, the debtor stays in business, continues to employ Vermonters, and contributes to the economy. At the same time, creditors receive more than they would get if they were involved in a liquidation kind of bankruptcy. They have the option then of maintaining an ongoing business relationship with that business. And they have the bankruptcy court holding the business accountable to make sure it stays current on debts as they move forward and just oversees the bankruptcy to make sure that fairness and access are ensured. Since the Bankruptcy Code offers so many options for reorganization, business owners who timely seek this relief will be able to continue their business, or they can wind down their business, or they can transfer their business, or they can sell a portion of their business in any way that they design through the reorganization process. And it allows them to retain their sense of dignity and be confident that they acted with integrity toward their employees and their creditors and their customers. I see that play out all of the time. Bankruptcy reorganizations, though, are quite complicated. And one of the first and most critical decisions any business needs to make is who to hire as the professional lawyer who is going to guide them through the process. Simply put, it is not prudent to attempt a bankruptcy reorganization without an attorney who has expertise in bankruptcy law. And the reality is, if you are an incorporated business, federal law prohibits you from appearing in federal court without an attorney. So that's an important determination. The second most critical decision is when to seek a reorganization. All of us on the panel today, and really any bankruptcy expert that you ask, will tell you that one of the biggest mistakes and one of the biggest causes of failure in reorganization is that the business waited too long to file. It's crucial to begin the reorganization process while the business still has sufficient cash flow to finance the cost of the experts and professionals that you'll need to guide the reorganization, and also while you still have goodwill with your creditors. The more that a business has of each of these, the more likely it is to succeed. Vermont has a very experienced and savvy bankruptcy bar on both the debtor and creditor side, as well as many professionals, appraisals, accountants, et cetera, who have skills and experience in bankruptcy and can provide critical relief for the debtor business in terms of which path to go down and which procedures are going to be most helpful. And these professionals understand the value of bankruptcy reorganizations, and they can give pragmatic advice, and they have a track record of facilitating good outcomes. If you contact one of them before your business is out of cash and still has goodwill with creditors, the odds of a viable reorganization are extremely high. This is particularly so in Vermont, where we have one of the highest national success rates of reorganization cases. I believe this is largely due to effective collaboration and a shared view of how valuable reorganization can be among the bankruptcy attorneys and trustees and court. So if this is something that's of interest and may seem like it could work, there are a lot of factors which would support success because you're in Vermont. The information we have in a chart that we've handed out to you today is general, and there are many exceptions that apply. We wanted to make it a user-friendly chart, but we also want to be clear that you can't just rely on it as it is, as legal advice. It does give you accurate generalizations, but it is really just an overview to illustrate the breadth and variety of relief that's available through bankruptcy reorganizations. We hope it will assist you as we go through a hypothetical a little later that Alex and Don will be focusing on, and be a good general resource for you after the program. One of the questions that we know people are wondering about is how long a bankruptcy reorganization will take. And that varies based primarily on two factors: what type of reorganization the business seeks, and we're going to be talking about all of them as we go through the program today, and the extent of creditor opposition. So as a general rule, if we assume that day one is the day that the business files a bankruptcy petition, the most important thing about that is, as I said before, the stay goes into effect. And the petition is essentially a revealing of your assets, your debts, and the answers to some questions about your financial circumstances. 14 to about 180 days after that, which I know is a big window, will be when the business must file a plan of reorganization. And when that's filed and how long that document must be and how complicated that document must be all depend on which kind of reorganization you've chosen. It essentially will set out how the business intends to restructure the finances or restructure the operations in order to go forward more profitably. It needs to indicate how it's going to pay its creditors and when. and what the source of those payments will be. At the same time, the debtor is preparing this plan, creditors have the obligation to file proofs of claim, setting out how much they assert the business owes to them. And those two things obviously work together to make sure that the plan is going to be accurate and successful. Within a couple of months of that plan being filed, the court will hold a confirmation hearing. And at that point, creditors have an opportunity to speak up. But the primary party in charge of that hearing is the debtor. The debtor has the burden at that point of proving that the plan that it's proposing is fair and reasonable and consistent with the bankruptcy code. If there's a dispute, then the court decides if it's fair or reasonable and feasible. But most often in Vermont, by the time we get to a confirmation hearing, the debtor and creditors have reached an agreement, so it becomes a consensual plan. And then for 3 to 5 years after the plan is confirmed, the debtor carries it out. They make the payments that the plan calls for, and they file reports periodically to keep the court and creditors informed of how things are going. When the plan is done, the debtor exits from the bankruptcy reorganization, essentially with a fresh start. And if it's an individual debtor, they will get a bankruptcy discharge, which effectively is a forgiveness of their debts. So we will go into that a little further as the program goes on, but I wanted to just give you that broad overview of the timing. I also want to thank Vermont Law School and the Vermont SBDC for inviting me to be here with you today, and to let you know that my co-panelists and I look forward to hearing your questions, and we will stay as long as it takes to answer all of your questions. It's our goal that by the end of today's program, you'll see how reorganizations and restructurings under the bankruptcy code can be valuable options for a small business to consider, not only to avoid having the business close down or suffer financial demise, but also to enhance the business's ability to thrive, which we actually see quite regularly to be the outcome. And with that, I will turn it over to Alex to go through the PowerPoint.
Thank you, Judge. Hello, everyone. My name is Alexandra Edelman, and I'm attorney at PRIMMER, Piper, Eggleton, and CRAMER in Burlington. I'm going to give you a brief overview of bankruptcy. And here we go. This is an overview of bankruptcy law, so you have an understanding of some of the basic concepts that we're going to discuss today. First, I'll go through the twin pillars of bankruptcy, which are two concepts, one of which is equality of distribution of available assets among similarly situated creditors, and also this concept of a fresh start for honest but unfortunate debtors, which is really a crucial part of bankruptcy. Some of the main bankruptcy policies that we want to focus on is this concept of equality of distribution, which is priority given to creditors that hold certain types of debt, and a pro rata distribution for similarly situated creditors, which prevents a race to the courthouse for creditors trying to collect from businesses and individuals. Another very important policy, which I mentioned before, is this concept of a fresh start. When a bankruptcy case is filed, an automatic stay freezes collection activity, which gives the debtor a breathing spell, which is often really critical. And there's a discharge at the end of the bankruptcy that releases the debtor from personal liability for certain types of debt, and a permanent injunction on collection, which basically means that none of that debt can ever be collected. And federal and state laws allow debtors to keep certain assets. Some property is exempt in the bankruptcy, which we'll discuss in a little bit. Another important bankruptcy policy is the concept of maximizing value of assets and distributions. Bankruptcy obtains the best possible price for assets, financing, and new equity to maximize recovery for creditors. And it also reorganizes and rehabilitates businesses, which can preserve jobs. Now, who are the parties in a bankruptcy? I'll talk about the four main parties today. The debtor is the individual organization that has voluntarily filed a bankruptcy petition, or in some cases, which are rare, is the subject of an involuntary bankruptcy that's been filed by creditors. Then there are the creditors, who are individuals or organizations which the debtor owes money, or claims to be owed money by the debtor. And the debtor in possession, in some cases, a debtor maintains possession and control of all of its assets, which means that the existing management in the business stays in place throughout the bankruptcy. And then there's also a bankruptcy trustee, which in some chapters, there's a representative of the bankruptcy estate who exercises statutory powers, principally for the benefit of unsecured creditors. And trustees are always appointed in Chapter 7, 12, 13, and Chapter 11, Subchapter 5, all of which we're going to discuss. There are three types of debt, and these are important concepts to understand in a bankruptcy. The first is secured debt. Secured debt is debt that's backed by a mortgage, pledge of collateral, or other lien. Examples of that would be home mortgages, auto loans, and tax liens. And then you have non-priority unsecured debt, which is debt for which a creditor holds no special assurance of payment that is generally dischargeable. Debt like that includes credit cards, medical expenses, and personal loans. And then there's also priority unsecured debt, which is debt that receives special treatment and gets paid before other unsecured debt. Examples include alimony, child support, employee wages and benefits, consumer deposits, and most tax obligations are priority unsecured debt. There are three main types of creditors in a bankruptcy. The first are secured creditors, and these line up with the types of debt that we just discussed. Secured creditors have a lien on certain property of the debtor, and the right to take and hold or sell that property in satisfaction of some or all of its claim. Usually that's a bank or a credit union. There are priority unsecured creditors, a creditor without a lien that is entitled to be paid ahead of other unsecured claims, such as the IRS and employees who are owed petition wages. And then finally, general unsecured creditors. Those are creditors that don't have a lien and don't have any priority in payment. They get the same percentage of distribution as any other similarly situated creditor from all the funds that remain after professional fees, secured claims, and priority unsecured claims are paid in the bankruptcy. We're going to discuss 5 of the chapters in bankruptcy that are relevant here today. There are 2 other bankruptcy chapters actually that we're not going to discuss, chapter 9 and 15. They don't really have any relevance today, so we won't go into those. But these chapters are worth highlighting for you. The first is chapter 7, which can be filed by either a business or an individual. And this is a bankruptcy that involves for a liquidation or the sale of the debtor's non-exempt property and the distributions of the proceeds to creditors. This liquidation in a chapter 7 is administered by a trustee. Then we have chapter 11, which is filed by either a business or an individual, and it provides for reorganization, typically of a larger corporation or partnership. That's the typical chapter 11 case that you'll see. And a Chapter 11 debtor usually proposes a plan of reorganization to keep its business going and to pay creditors over time. And as I said, both people in business and individuals can seek relief under Chapter 11. The court holds a confirmation hearing, and at least one class of creditors has to support. Basically, they have to say that they approve the plan in order for it to be confirmed. Then there's Chapter 11, Subchapter 5, which the judge mentioned earlier. This is a newer chapter in the bankruptcy code that is exclusively for small businesses, which we want to focus on particularly today. It provides for reorganization of small businesses and allows a debtor to pay its creditors over time. A trustee is automatically appointed, but the debtor remains in possession. They retain control of the assets and operations of the business, which is usually a very nice part of the Chapter 11, Subchapter 5. The process is a lot quicker than a traditional Chapter 11 and has many less administrative costs. Then there's Chapter 12, which can also be filed by a business or an individual, but this is exclusively for the adjustment of debts of a family farmer or a family fisherman. And then finally, Chapter 13 can only be filed by individuals, and it provides for the adjustment of debts of an individual with regular income. The Chapter 13 pays debts over 3 to 5 years and can also include voluntary sales of property. And as we'll discuss later, sometimes a Chapter 13 will go hand in hand with Chapter 11, Chapter 5, if there are significant individual and business debts. Some of the questions to consider when deciding whether or not a reorganization or bankruptcy is appropriate for a small business. The first question really is, what is the business trying to accomplish? And we're going to talk in detail when we go over our hypothetical later on about, a situation where these questions are asked and how we apply them. But the first really is, what is the business trying to accomplish? Is it going to continue its operations? Is it going to try and expand its operations? Is it changing or streamlining the scope or nature of the business? Are those things that are appropriate or appealing to the business? Is the business able to work out debt directly with the lenders? That's an important consideration. Is there a way to reach arrangements with the lenders that would allow the business to continue without having to file for a bankruptcy? Is the business thinking about selling all or part of the business? Or unfortunately, do they have to go through an orderly liquidation of the business? Is the business interested in reorganizing operations or restructuring a business entity? And is the business going to have to wind down operations and do an immediate liquidation? These are all questions that a business will have to ask itself when it's trying to figure out what the next best course of action is. And we'll talk about that in further detail when we go over the hypothetical. So if there is a bankruptcy filed, there's the creation of a bankruptcy estate. And this picture shows basically the way it works. So all of the debtor's assets pre-petition go into this big bucket, which is the bankruptcy estate. Those are all the debtor's pre-petition assets. And then some of the property that's exempt from the bankruptcy, which I'll give you a list of those in a minute, gets out of the bucket, and then the rest of it is available for creditors. And here's some of the common Vermont and federal exemptions for individuals. So in Vermont, the equity in your home is up to $125,000 is exempt from bankruptcy. The federal limit's a little less, it's $25,000, significantly less actually. The equity in your car or truck that is exempt, $2,500 of that is exempt. Under the federal limit, it's $4,000. Tools of the trade, such as equipment that you use for your business, $5,000. The federal limit is $2,525. Household goods, $2,500 of those are exempt from the bankruptcy estate. Federal is a little bit less. There's a wild card exemption, which is basically anything you want. Up to $400 of that can be exempt. It's higher under the federal limit. And then there's some other exemptions. The benefits, there's no limit. Those are all exempt. So, and these are just very general descriptions of the exemptions, but this will give you an idea of the principal things that are exempt from bankruptcy estate, which is an important consideration as well. And we just talked about the concept of equity and how does that work? So in order to calculate how much equity you have in something to determine whether or not it's exempt. So here we have a car that's worth $6,000. It has a $4,000 car loan balance on it. So then the equity is $2,000. So that equity would be exempt in the car. And it's similar with a home. If the home is worth $100,000 and it has a mortgage on it of $80,000, then $20,000 of that home is equity, and it's exempt from the bankruptcy estate. So here's some considerations as to why you would file under Chapter 13. These are some important considerations, and I think they're the main ones to think about. So when you file for a Chapter 13, it stops any foreclosure proceedings. And if you make all your plan payments, you can reinstate your home mortgage and keep going with your mortgage payments to keep your home. Chapter 13 debtors can cure default secured debt over the plan term as well, which is really important. And then Chapter 13 debtors can pay delinquent taxes over 5 years, which is the life of the plan, with no post-petition interest. So no interest will accrue on that delinquent tax debt, which is really significant. Why file under Chapter 11, Subchapter 5? This is the one that we talked about earlier. This is exclusively for small businesses. This is a newer area of the code, and it's really great for small businesses. It's much less costly and a much quicker process than a traditional Chapter 11. There's increased flexibility to restructure debt with creditors. And the debt limits were actually just increased to $7.5 million to help small businesses through March of 2021. That may be extended, we don't know that yet, but $7.5 million is a pretty significant amount of debt. So that opens us up to a lot more businesses. And then here's some considerations for filing Chapter 12. This is the chapter that's exclusively for family farmers, family fishermen, with regular annual income. We see many of these in Vermont. Chapter 12 is a more streamlined and a less complicated and less expensive process than Chapter 11. It makes allowance for situations in which family farmers and fishermen have income that is seasonal in nature, because a lot of those farmers and fishermen only have income coming in part of the year. And there are significant tax benefits in the Chapter 12. If part of the farm is sold, that results in no capital gain liability to the debtor. So that is the end of our overview. I guess we'll go to questions at the end. We're going to now go into our hypothetical.
All right. Well, thank you, Alex. So good afternoon, everybody. We're going to throw a hypothetical out to you. I believe the hypothetical fact pattern has been placed in the chat, so you can certainly download it so you can follow along at home. There are a lot of moving parts, I will say, in this fact pattern. We did try to, address a number of issues that come up with small businesses. So, not all small businesses may face all of these issues at once, as our hypothetical company has, but there may be elements of this hypothetical that apply that you can identify with. So we'll start with this beautiful company, Trinkets of Vermont, that was started by a lovely husband and wife team back in 2007. They specialize in selling Vermont-themed goods, housewares, maple-themed products, dairy items. Most of the items that they sell, or many of them at least, are made right here in Vermont. The initial investment in the business came from the husband and wife team. They took a home equity line of credit on their marital residence, which is located in Pomfret, Vermont. TOV mostly operates as a brick and mortar business. They have a retail space in Woodstock, and like many businesses along this line, they benefit from the tourist traffic during the ski season, certainly over the summer and over the fall. They launched in 2018 an e-commerce site. And the e-commerce site sold many of the same products that they sell in the store, but now they could sell it to a much wider audience. Also in 2018, they had an opportunity to buy the retail space that their store is located in Woodstock, which they jumped at. Things were going well, so why not take the plunge? So they bought the building. They hold the building in a holding company, a real estate holding company, and then the business, TOV, essentially leases from the holding company. They, in the midst of all this, as many businesses do, they obtained an American Express business credit card, probably some other debts along the way as well. And the credit card is used, primarily to help meet, cash demands when the cash flow may not may not be there. In 2019, they began exploring the idea of opening a second retail location. Things are going well, why not expand? So they signed a 5-year commercial lease on a place in Stowe, Vermont, again, hoping to capitalize on that tourist traffic. Well, the retail space, the husband and wife, by the way, guaranteed the lease, which the business owners are often required to do. So this is not all that uncommon. But unfortunately, the retail space needed a lot of work. They really wanted to capture the essence of Trinkets of Vermont. So, a lot of exposed beam and things like that. It was going to take a lot of work. So they took out a commercial loan, again, not all that uncommon, to finance the construction. Well, the loan is secured by the real property in Woodstock, Vermont, an ABA, or essentially a blanket business asset securitization. And then they have a guarantee. So they personally guaranteed the loan as well. Oh, there you go. Look at that. I guess I could have done that too. Thank you for putting that up. And then the husband and wife also signed a personal guarantee on the commercial loan. They began the work immediately, but unfortunately, they ran into some snags. The contractor fell behind, and they ran into cost overages and things of that nature. There may potentially be a cause of action for a breach of contract. But the bottom line is they had a hope or an expectation that they'd be able to capitalize on maybe some of the holiday season, maybe some of the ski season, but that quickly went away. Now, keep in mind, this is back in November 2019, a much different world back in 2019. Well, then unfortunately, COVID hit. And the stay-at-home orders went into effect, and the traffic, essentially stopped. They didn't have the Stowe store open, and now they were really facing a crunch because they weren't getting nearly as much foot traffic as they did at their Woodstock store. At the time, they had their Woodstock store fully staffed, 3 full-time employees, but obviously the abrupt drop in income caused quite a strain. So the business applied for and received, as many businesses did, a PPP loan, which helped the business pay its employees and meet some operating expenses. But since the location in Stowe never officially opened, the rent became difficult to make. Now they're paying for, this facility that they're not yet able to use. The husband and wife team were able to divert some personal funds to make payments. But in May of 2020, they realized that they weren't going to be able to, continue to make these payments. Now, the good news is, and this is the thing that makes reorganization an interesting idea, is that the online component is actually doing very well. And based on projections, if it continues, the business may be able to cash flow. But unfortunately, they've run through cash reserves. They don't have a lot of money left. And it appears that if they don't do something soon, they're going to have to make some really, really tough choices. In addition to that, they're obviously facing threats on a couple fronts, but now American Express has decided to rattle sabers and is really trying to amp up the efforts to collect. They have approximately a $25,000 balance. So this is, again, we're covering a lot of issues, but this is, not all that uncommon a tale that businesses are confronting. So what are they to do? They'd like to continue to retain the business and continue its operation, but they're really, up against a wall as to what their next steps might be. So I think, if I'm not mistaken, Your Honor, we're going to allow you to sort of pick apart the fact pattern and maybe pose some questions to Alex and I as far as how we should advise this business.
Yes, and I don't think it's so much about necessarily how you would advise them as much as what questions you might ask.
Yes.
And I think you started out by saying, they've already pretty much decided they want to keep the business and continue operations. And that's a huge decision. And that sort of is one path that opens up particular doors that would otherwise not be open. And so, what other options do they have? We've got here in our hypothetical, potentially a sale at, bargain basement prices, or, a sibling coming in but wanting to have a big chunk of the ownership and therefore control over the business, or a potential family loan where your elderly parents are going to end up with a mortgage on their house. And these are all options that I think many of us have seen. And I guess I would be interested to have you two talk a little bit about what you see as the pros and cons of those, and how they would tie into whether a reorganization could help and how it would change their options.
Sure. I mean, and I'll start off and then turn it over to Alex. I think that what we're seeing is you have a business that potentially has some revenue centers in terms of this online commerce. And obviously, once the stay-at-home orders are lifted and we see more tourist traffic, the retail spaces could begin to cash flow. So it's possibly a stopgap. Now, the issue is, and many businesses confront that, you have to wonder whether taking on more debt really solves the problem. While it may, give you a little bit more cash on hand to manage some of the, the cash flow issues, it also creates an additional obligation. So, this could in fact be one of those instances where more debt is not necessarily the solution, and also dragging family members into it. The home, the mom and dad mortgaging the property, just poses some additional risk that may not be, while well-meaning, well-intended, it may not be the best idea. We always hope that things like this are going to help us resurrect the business, but the reality is, if it takes a turn, you certainly don't want to be the one responsible for your mom and dad now being homeless. Alex, what are your thoughts?
I would agree with all of those points, Don. Well, one of them I wanted to bring up is this concept of getting bought out by a big box store, and only wanting to pay off the secured debt. And there are some issues there, which is that there's still a lot of unsecured debt out there. And how do they deal with that? Is that going to solve their problems? Is the money that they're going to get for the box store going to be enough to continue operations with all of this unsecured debt out there? So that's an issue. I would also say that, one of the first considerations is, and I referenced it earlier, was have they reached out to their lenders to see if there is a way that they can work something out, and try and restructure their debt, with their secured debt mostly with their lenders, even their unsecured debt, if there's a way they could enter into some type of payment plan. So those are some early on considerations that may be, investigated and explored if they want to continue operations.
Well, and there's also the lease question. I mean, maybe the two of you could talk a little bit about what happens to that lease if they chose to file for a reorganization under the bankruptcy code. Can they just walk away from the lease?
Effectively, yeah. I mean, they can put as part of their plan the ability to reject the lease, which can conveniently get them out of this 5-year obligation. So yeah, I mean, I think in that instance, the bankruptcy becomes, the possibility of reorganizing under the bankruptcy code becomes potentially a real lifesaver.
But we've got the personal guarantee on the lease, right?
That's right. So the personal guarantee, and actually, Your Honor, I was thinking as Alex, was talking about the big box, buying out just the secured debt. We've got two issues, right? I mean, you've got the commercial loan, which has a personal guarantee, and you've got this lease that has a personal guarantee. Not to mention, the initial investment that was taken by using the home equity line of credit. So while certainly a reorganization would allow you to reject that lease as a business entity, it's obviously going to create, the potential for it's going to trigger the personal guarantee, which is one of the reasons, it may be advisable to recommend both a subchapter 5 and a personal chapter 13 to address, the discharge of that personal guarantee.
And so maybe Alex could put up on the screen the chart that lays out, how the subchapter 5 would actually work a little bit. And to talk about, for example, is there any difference among the various types of bankruptcy relief with regard to the creditors who are threatening lawsuits? Are they better off? Is a debtor or business better off in one chapter rather than another for purposes of getting those lawsuits stopped?
Can everyone see the chart?
No.
Not yet.
Huh. Hold on a sec. It's up on my screen.
Well, it is up in the materials.
Sometimes it takes a minute for the screen share to switch, so hold on one second. Still not sharing. I'm going to stop the share and I'll try it again.
Yeah, sometimes if you stop and start the share, it helps.
Okay.
So Don, while Alex is doing that, can you talk a little bit about the stay of collection activity? Does it matter what chapter?
It actually doesn't as far as the automatic stay is concerned. So upon the filing of the case, this thing called the automatic stay goes into effect. And it essentially prohibits creditors from doing anything to attempt to collect a debt. So it really does cut off this idea of a rush to the courthouse. And the stay is really, it's a temporary device, but it goes into effect again as soon as the case is filed. The second we do things electronically these days, so the second you hit submit on the button or on the petition and it's received by the court, the stay is theoretically in effect at that point. And that in and of itself, Alex mentioned, that breathing room, that in and of itself can be extraordinarily powerful because it gives you now the opportunity to take a step back, to assess, and to come up with a plan of attack. So the stay, I think is probably one of the most when the creditors are rattling sabers. I think that's probably one of the most powerful aspects of the bankruptcy code at that moment.
Well, and you said that it's temporary, but it's actually in place as long as the case is pending, unless the creditor comes into court and gets relief from stay. And of course, that would never happen without the debtor knowing. There isn't any reason for the debtor to worry about that.
Right.
No surprises.
Right. And that is a really that's an excellent point. I mean, it is, the only way a creditor, you're not going to get blindsided. You now have, the benefit of the case being before a bankruptcy judge in this forum where rights, any interest of the parties has to essentially come through the court. So there are no surprises.
And in terms of talking about the subchapter 5, you mentioned, Alex, before about the significantly increased debt limit that's governing subchapter 5 right now. I think it might be useful to talk a little bit too, and maybe each of you could address this, about how and why there is a trustee in subchapter 5 of chapter 11, whereas just a regular small business debtor who chooses to file chapter 11 could actually operate without a trustee. What are the pros and cons of having that trustee in place?
I mean, I'll start. The trustee is a really helpful part of the subchapter 5. The trustee will, be in charge of administering the case and making sure that everything is done properly, and is there, as sort of a referee to keep watch over everything and to be there as a resource.
Yeah, and I think, I mean, the big thing that distinguishes sort of a sub 5 trustee is that the trustee is really there to facilitate a consensual plan, to work with parties on cash flow, maybe adjusting interest rates, payment requirements, things of that nature. Trustee acts as a mediator. So you immediately get, upon filing to the subchapter 5, you get this, theoretically, this expert who, really wants to see, is almost obligated to engage in a proactive process to get a consensual plan. And that requires, a degree of sophistication that the business itself may not have. So yeah, I think, the whole idea of having a facilitator is really, really valuable and worth the price of admission right there.
Well, and moving on to what we've labeled as our third question in the hypothetical, what are TOV's options? I mean, does TOV actually have any right to file a 12 or 13?
Well, they wouldn't be able to file a 13. Well, they wouldn't be able to file either. And Alex, if we, I think, are we at the eligibility piece? Right.
Yeah.
So chapter 12, they're not, 50% of the income is not derived from a farming operation. So I think we can, scratch that one off the list. And then the 13, they're not an individual. TOV is incorporated, they're a business entity. So chapter 13 is not available for TOV itself. It is, however, available for the husband and wife team should they seek, to file personally.
And can TOV actually go through a refinance? I mean, Alex talked about trying to work something out with the lender, and if the lender isn't willing to, sort of modify the debt, but might be willing to do some sort of refinance, is that something that can actually be done even if an entity is in a bankruptcy case?
Oh, Alex,
I wasn't sure if Don was going to take that or not. Yeah, yes, that can happen in the context of the Chapter 11 sub 5, and what, as we talked about, that can happen with the benefit of the stay in place, so that they can have some breathing room and they can still refinance their debt, which is often a lifesaver. And the lenders really need to work with them to try and make it possible. And at the same time, they can deal with their other debt as well, not just the secured debt, but some of the unsecured debt that they have as well. So all of that can happen in the context of the Chapter 11 to Chapter 5.
Yeah, I think, members of the audience may have heard the term DIP financing or DIP financing, as some people call it. And that's precisely what this is. It's financing that would happen, within the confines of a Chapter 11 case. And I think the other piece that's important regarding the financing and refinancing is sometimes we see situations where an entity may be reluctant to seek bankruptcy relief. And so they go out and they do a refinance, and they encompass in that refinance unsecured debt. For example, American Express, who's calling them 17 times a day, to get rid of that debt, the business may say, fine, I'm going to refinance, this mortgage debt, and I just want American Express off my back. So I'm going to pay them too with the refinance. And while you may get some peace of mind from that, the reality is you're now converting what was unsecured debt that was going to be paid just a portion of the amount due probably in a reorganization case, and elevating them up to a secured creditor that has to get paid in full. So I think one of the pieces of information we want people to at least think about is, if a refinance seems like an option that could be useful, think carefully about whether that refinance is more effective before or after, a reorganization case is filed.
So we have,
Oh,
Go ahead.
I was going to suggest we have a couple of questions that have come in, and one that I think really sort of gets to the heart of what people don't understand. It would be really helpful to understand the relationship between the parties. Who does what? The lawyer versus the trustee versus the judge, and of course the business owner. So what roles do those involved play? And in addition to that, can a creditor get themselves in trouble for suggesting that a company consider speaking with counsel or filing bankruptcy? So what role does a creditor play?
Well, I can start, and then I'll let Don and Alex chime in on that one. In terms of the role that the debtor business plays in both a subchapter 5 or a sort of regular conventional Chapter 11, the business is still intact and in possession and in charge of its own operations. The subchapter 5 trustee is there to give advice, but the debtor can choose whether to take that advice. So the debtor is really running their own business in Chapter 11. The role of the attorney is to essentially navigate the process and advise the debtor about what their obligations are, what they need to do, the documents they need to file, what their rights and opportunities are in the reorganization, it's much more of a professional guide through the process. And creditors get to vote on these plans, and so they have a say. And to the extent there is some negotiation to stretch out the terms of payment or to perhaps defer certain payments until later, the more negotiation the debtor can accomplish with creditors to get a plan that the creditors will go along with, the better. And the judge's role is really to just resolve disputes. I would need to make the findings, what they're called, that the debtor has done everything they need to do to be qualified to get a plan confirmed in bankruptcy. But as a general rule, as long as the plan is consistent with the requirements of the bankruptcy code, if the debtors and creditors are in agreement, I don't have much to do in that case. But if there is a dispute as to whether a plan is fair, whether the creditor is getting paid everything they're supposed to, whether a mortgage is valid or not, any of those sorts of issues that arise, the attorney for the debtor and attorney for the creditor present their arguments, and then I'll make a decision on that. Don or Alex, anything to add?
No, I think you it's a great summation of what the various roles are. I think the one theme that kind of brings all these players is this concept of a consensual plan, at least in a subchapter 5, and that really does, the debtor, obviously, as the business owner, is required to provide forms and help complete the petition and all that kind of stuff. As we mentioned earlier, the trustee is really going to act as a facilitator. And then the creditors, I think, kind of face the economic reality that, a plan of reorganization is probably, better than liquidation, probably better than some of the other alternatives. So oftentimes, I think creditors in the context of a bankruptcy filing are, I wouldn't say more willing to negotiate, and Alex can certainly speak to this, but, feel as though their best shot at being paid something, if not in full, is going to be through, good faith participation in the process.
Yeah, I would agree with all of that. And I would also just add that the nice thing about the bankruptcy forum is it brings everyone that has an interest to the table, so that the business owner is dealing with every, creditor that it has relationships with, and everyone is brought into the same forum to hopefully reach a consensual plan that works to everyone's best interest.
I think this particular question was answered, but I wanted to highlight it because it seems to be a point of interest. How are personal financial guarantees treated after filing bankruptcy? And sort of, just to highlight what you said earlier in the presentation, because I think it was addressed, but specifically, if they've, if Uncle Joe loaned them money, what's going on with that?
Oh,
well, I can remember from when I was in private practice, that was always one of the questions that businesses or individuals would ask. Goes, Uncle Joe loaned me money and I really want to pay him back, so I'm just not going to mention that in the bankruptcy case. Wrong. All debts need to be listed. And if there is a personal guarantee, that guarantee is not affected at all unless the person who signed the guarantee files for bankruptcy. It's always going to be valid. Now, there are a number of instances where a business will file a bankruptcy reorganization case, and the plan calls for that debt that has the guarantee to be paid in full. And usually you can work out an arrangement. We see this a lot with the IRS. The IRS has the responsible party liability that they can impose on the owners of the business. And they will generally agree that if the plan provides for full payment, they will not go after the individual guarantors. But it doesn't mean that the guarantee isn't still valid. I mean, if the debtor doesn't make those payments through the plan, you can be sure the IRS or whoever the entity is that holds that guarantee will be quite eager to enforce it. But that's also why, Don and Alex were talking before about, we often see the guarantors filing their own separate, typically Chapter 13 case, and then they're paying part of it through the Chapter 13, and part of it's being paid through the business reorganization case.
Another question here is, what say do people have in who the trustee is and who appoints the trustee?
They have no say.
None.
No say at all.
That covers that.
Short answer.
In 1978, without going into a whole lot of detail, Congress decided to have the administrative side of bankruptcy cases overseen by the Department of Justice. So it's the Department of Justice under the agency of the U.S. Trustee's Office that appoints and monitors and supervises trustees generally. Occasionally courts get involved in those issues, but only if something has gone wrong, usually.
There was a question earlier, and I think just for clarity's sake, do you mean that an individual and their business can both file bankruptcy and they're separate?
Yes.
So if you could address that and just give a little more detail on how that would happen in the timeline for it.
I mean, they're treated as two separate cases, but oftentimes they go hand in hand. Don probably can speak better to this. I mostly represent creditors in these cases, but usually, if business files a Chapter 11 or Chapter 11 sub 5, and then the individual business owners file a 13, a lot of the deadlines and requirements, because there's the same bankruptcy judge, a lot of that stuff overlaps and they happen together, but they are totally separate cases, and they deal oftentimes with different debt obligations.
They can be jointly administered, which is a convenience since the players will essentially be the same. So it is a way to, create a little bit of overlap. But the relief is going to be different. The relief for a Chapter 13 individual debtor is going to be different than the relief for the business filing the Subchapter 5.
And a Chapter 13 is much simpler. In Chapter 13, there's what I call a formula plan. You don't have a lot of choice on what form you use. It is the formal form for Chapter 13 plan, and you just fill it out. It's just a few pages. A Subchapter 5, Chapter 11 plan is really much more open-ended because different kinds of businesses have different kinds of needs and proposals. And so it often takes a bit longer to get a Chapter 11 plan of any kind together. So they're really operating differently. But as Don and Alex said, we do our best in Vermont to sort of put them together through a joint administration process. So the attorneys have to show up in court on the same days, and the treatment of the creditors is at least consistent. We don't have one case trying to void a mortgage because it wasn't properly executed, and the other case saying we're going to pay it in full. They are totally aligned, and they usually work quite well with that joint administration process.
So a few more questions here. These are great questions. Please keep them coming. This one is from one of the business advisors, and they suggest that businesses will often access credit that is not advantageous to them, i.e. having interest rates that border on usurious when beginning to run into trouble. So predatory lending. During a restructure, can some or all of this interest be discharged, renegotiated in a reorg? How does that work? And is this another way that bankruptcy is helpful potentially?
Yeah.
Definitely.
Yeah, go ahead, Alex. Go ahead.
Yes, the interest rate is definitely something that can be modified through the bankruptcy process to make sure that it's a fair rate. And then other aspects can be modified as well. I'll let Don, you want to chime in, go for it.
Yeah, I mean, I think that, that's probably one of the most powerful tools, is this ability to, to restructure and reorganize. And, it's unfortunate that businesses sometimes have to rely on the availability of predatory, lending, but it's also the reality when there's a cash flow crunch. Sometimes, desperate times call for desperate measures, but you do have the ability to renegotiate, and in some instances discharge those debts, which is really very powerful. And I do a lot of consumer debtor work, and it's usually the unsecured creditors, the people who are absolutely at the bottom of the pile, that clamor the loudest. And there's a tendency sometimes on the part of consumer debtors to want to pay, in some instances, pay the credit card before they pay their mortgage, or before they put food on the table, or things of that nature, because they just want the phone calls to stop. And while that makes perfect sense, it's often not the best use of limited resources. And that's where I think the bankruptcy code really, creditors are going to use every tool available to them, and Alex can speak to this, every tool available to them to collect from a debtor. The bankruptcy code is a way for the debtor to sort of level the playing field, to now use this extremely powerful tool to help them negotiate and deal with the creditors on a level playing field.
Yeah, there's a concept in bankruptcy, which is a crude sort of sounding term, but anyone in the bankruptcy world has heard it many times, which is cram down. And what that is an opportunity to adjust the amount due on a secured debt to be no more than the value of the collateral. And so the classic cram down is a car loan. So if you have a car that's worth $5,000 and the balance due is $9,000, and these sorts of upside down loans we see all the time, largely because debtors are rolling over debts from previously owned vehicles when they buy a new vehicle. But in that example, the car loan would be paid $5,000 as a secured debt, with interest, whatever interest rate is allowed. And that remaining $4,000 of debt would become an unsecured obligation, and they would get 2% or 20% or 50%, whatever all the other unsecured creditors were getting. So that's a huge benefit. And that applies to all kinds of debts except debts that are secured by the debtor's principal residence. As a general rule, there are exceptions to that too, but we won't go there. And, at the risk of getting a little technical, I would just say that in terms of interest rates, the rule in bankruptcy courts is that, at least in the Second Circuit, is the TILL, TILL rate, which essentially says that courts can adjust the interest rate on a secured debt to be what ever the prime rate is at that time, plus 1 to 3%. And it's a small range. And the idea is that if the debtor has a good payment history, then it would be prime plus 1. If they have a really awful payment history, then it would be prime plus 3. But that's a radical reduction if you're talking about somebody who had a loan that they got, from a lender that was really charging excessive interest rates. So there is a huge amount of relief on that front, to answer the question.
So we have another question. And there's two questions here, and I'm going to sort of blend them together because they're sort of around the same subject. Typical range of costs for bankruptcy. I understand this is a broad question, but is there a minimum cost a business should expect? And coupled together with that is, since this is bankruptcy, how do the filing fees happen, and how do you pay the lawyers, and is the cost worked into the plan?
So Don, this sounds like your question.
Yeah. So the cost, it varies, of course. I mean, that's an attorney's favorite answer. It depends, and it does, and it depends really on the type of relief being sought. how complicated the case is, things of that nature. There are some, rough estimates. So in the handout that we provided, you can see, looks like it's on page 4, the overall cost. At Chapter 11, your traditional Chapter 11 can be fabulously expensive for a small business. It's not uncommon for it to be up in the neighborhood of 50, $30 to $50,000 depending. A Subchapter 5 is going to be less expensive. It's going to be expensive. There's going to be some cost involved, but you always have to look at the cost. In this case, we estimate possibly 15 grand. You have to look at really what you're buying for that 15 grand, what you're getting in exchange for that investment. A Chapter 13 is generally going to be in the $25,000 to $5,000 range. And again, this is just for the attorney fee piece of it. We'll talk about the filing fees in just a second. And then, the Chapter 12 is sort of along the same lines, a little bit more expensive than the Chapter 13 for sure. A really complicated Chapter 12 case could run upwards of $50,000. But generally it's going to be, somewhere in the range of $5,000 to $50,000. So it's not cheap and it's not free. Many attorneys, we don't accept Bitcoin. I just want to throw that out there. But there is a fee. There's a filing fee, of course, for a traditional Chapter 11 and a Sub 5. The filing fee is $1,700, $1,738. A Chapter 13 for an individual is $313. And then it's a little bit less for Chapter 12 at $278. So if you think about those costs, again, if you're looking at a Subchapter 5, you might be spending somewhere in the neighborhood of, we don't have a floor there, but probably between 5 to 7 to maybe 15 grand for a Subchapter 5. And really you have to look at it in terms of what the business is getting for that investment. And it's the opportunity to live another day and to renegotiate some of these debts. So while the price tag seems, wow, the reality is you're getting a lot in exchange. And in many instances, the fees can be paid through the plan. So it's not as though, there's a requirement to pay the entire attorney fee up front. So hopefully that helps provide some broad range. And I didn't see too many people immediately leave the room upon mention of the fee. So I guess that's a good sign.
And that is actually another role of the court is attorneys who represent debtors have to have their fees approved by the bankruptcy court. And there's a requirement that the fees be, reasonable and necessary.
There is another question from an attendee. What obligations to customers if you file for bankruptcy? For example, if you're holding money for services that were not able to be delivered due to COVID. So there's a lot of cases where people are rolling things forward right now for event planning and things of that nature.
That's a great question. I'm going to defer to Alex.
I'm assuming there are contracts for those obligations, and there's an opportunity to probably negotiate with the customer on that, and potentially you may have to return that money if the customer decides they don't want to move forward with the obligation in the future. But I think that's not something that would definitely happen. I think it would have to be part of the whole negotiation that's involved in the Subchapter 5.
Well,
So
go ahead.
Does the customer become the creditor, I guess, is the question.
So the customer has paid the money, but and they are owed a service.
Correct.
So yes, they become a creditor in the case, and they would file a claim for what they're owed.
Right.
And I would just point out that there is, if the debtor is still holding the money, that money still belongs to the person who made the deposit. If it's been set aside and properly labeled and all of that, then it's still the property of the party who deposited it. And if the debtor has, just put it in with all of their other income, so it's not segregable, there is a priority for consumer deposits. And I think that what you're describing would meet the criteria for a consumer deposit. And so they would get relief that way as well.
Right, and you can imagine, it's probably often the case, in like gift cards and deposits and things of that nature that, while some businesses certainly may segregate those funds, you could also imagine, the very real scenario where those funds just come into regular cash flow, regular operating, and that could create some issues, and those issues could impact the ability really of the business to effectively reorganize. So it's definitely something that when a business is consulting with any attorney, exploring this as a possibility, full disclosure of that kind of stuff is really critical.
And the maximum amount of that claim is $3,025 for priority purposes. So they're not segregated. It's a little messy.
Right.
And if people want to find out more about filing bankruptcy, or they want to keep track of something, how does the average citizen engage with the court?
The bankruptcy court is fully electronic. And so there's the court's website, which is VTB for Vermont Bankruptcy.uscourts.gov. And also PACER, which is an acronym for Public Access to Court Electronic Records, is available, and for a very nominal fee, I think it's $15, one can register to have access to PACER. And with that, one can go into the system and either through the debtor's name, social security number, or case number, one can look at these records because they are all public information. So there's
the bankruptcy court has all of the forms that are used in the bankruptcy process are all on the bankruptcy court's website. And there's also uscourts.com is a website that has a lot of information for debtors about bankruptcy and the different chapters of bankruptcy as well.
And we have another question here from the audience. Clearly, this is a public process, but given the level of misconception regarding bankruptcy, and this is really a question to the sort of the feeling of shame and how to deal with the stigma of it. Do lawyers have experience handling the story to vendors, customers, and the public? And this particular business advisor notes that this is the primary concern for her clients in many cases. So how is it handled?
I mean, a bankruptcy filing is a public process, and if it's a business of some renown, it's likely that it's going to be, picked up by news outlets and things of that nature. So, there's certainly nothing that we can do to prevent that. I would say that, most of the bankruptcy bar were not necessarily public relations experts, but if a business is contemplating, a filing like this, and concerned about the public image, it's probably not a bad idea to consult, with somebody who might be involved in the media that can help spin it. Not necessarily spin it, but at least, at least present it to the public in a way that is not going to be damaging to the business. I understand why there is a stigma attached to a bankruptcy filing, but the one thing I tell consumer debtors very often is that, thank God that there is a bankruptcy code. And really, we have a very liberal bankruptcy code in the United States, primarily because it encourages entrepreneurs. Imagine if our husband and wife couple, TOV, who started this business, imagine if they just had to fold up shop and now they're saddled with all kinds of debt. The likelihood that they're going to be able to emerge from that, but for the bankruptcy code, is unlikely. And they may never start another business, business that, while they're only employing 3 people, is still providing, a living for a couple employees. So I think that, while the stigma piece is understandable, often because there's a lot of mystery surrounding, how a bankruptcy really works and how effective a tool a bankruptcy is. And, in the case of a subchapter 5, it's not an indication of failure, of business failure. It's more an opportunity for a business to plan for the future, to wrestle control back from creditors to try to give themselves some type of future. So I think, when businesses are thinking of this idea of a stigma, it really is important to look at it as a tool that doesn't represent, the Alamo. It represents, viability. It represents the ability of the business to continue to thrive. But as far as, getting the word out to the public, I don't think any bankruptcy attorneys are necessarily, we're not necessarily public relations experts. So I think if there's an image concern, it probably is advisable to consult with professionals who handle that kind of stuff.
And I think the other piece is that in this country, we have so many examples of large companies that, have successfully reorganized and have come out functioning better than when they went in. And, they were able to figure out what aspects of their business were most viable, were most productive, were most profitable, and really realign their resources and their skill set to explore and exploit those areas, and to let go of the areas that were not profitable and come out a much stronger company. And, I see that as, sort of an act of integrity, and, taking the honorable route, as one might say, of, doing what's likely to be best for the employees and the community and the business to keep moving forward. So, I understand the shame, and I can remember having lots of clients cry in my office about how ashamed they were. But, the reality is that whether you're talking about a business or an individual, I, as a bankruptcy judge, start with the premise that most people and businesses that come in before me to get bankruptcy relief are there almost all the time because of factors that were beyond their control. I think there's a misperception that bankruptcy courts or, the public somehow see people who need bankruptcy relief as people who were failures at something. And that's not the way I view it. And that's certainly not the way scholars have, discerned what's going on. They really do find that people who file for bankruptcy are there because of circumstances they didn't create, didn't have control over, and now they're actually taking control and trying to be proactive in restructuring their financial situation so they can be contributing members of society again. So I think to the extent a business consultant can convey that to a business that's struggling, maybe that will help.
Yeah, and I would just add that, subchapter 5 was just created because of the economic realities that this country is facing right now, and all the small business struggles that are out there. And it's a tool that, is meant to help these businesses thrive and continue to operate. And it is such a powerful tool, and it's not shameful at all. As the judge said, it's a very respected, and it's a really responsible way of dealing with some things that are out of your control.
Yeah, to underline that, this is actually the responsible path when you have this kind of situation. Irresponsible is pretending it's not happening.
Right. And, is often the case, the time that a business is having these sort of discussions, or the discussions, that we're talking about now in this hypothetical, for example, I mean, the paths to recovery are becoming limited. And, if you're concerned about the image that a bankruptcy filing might have, well, you also have the image of complete business failure, winding up of the business. And granted, that may be one of the best alternatives when all is said and done. But, a business who is hesitant to file or contemplate filing for bankruptcy relief because of, the stigma or the image that it might send to the community should also consider, the image that winding up the business, or having the business foreclosed, or the business properties sold at auction. So I think that when a business is facing some sort of existential crisis and is looking for alternatives, I think bankruptcy relief, the subchapter 5, absolutely needs to be on the table, to just see, if it can provide the relief that it's intended to provide.
And I think there's also what I would call the mental health piece of this. Whether you're talking about an individual or a business owner, the strain of financial distress, particularly if you add in the kinds of factors we're talking about with personal guarantees, or not being able to pay your employees, or bumping into people in the grocery store to whom you owe money, which is something that happens in Vermont. We don't have a lot of anonymity here. That's really dangerous, and I think for people who have gone through bankruptcy, they would tell you, and I hope they would tell you, that they felt a sense of relief from having filed. And they felt like, it was a respectful process. Nobody treated them as if they were losers. They left with a company that was able to meet its obligations, and the person could hold their head up high because they paid their creditors 20% or 50% or whatever it was that they know was the best they could do. And so, I really like to think of bankruptcy as a way of helping the company and the individual not only regain some financial viability, but also a way of maintaining a sense of dignity about doing what's best and knowing that they did what was best. So, I see that as a significant mitigating factor against any sense of shame that might be sort of a first instinct that would arise when you think about bankruptcy.
So I'm going to refer the panelists back to the hypothetical and ask if there are any of those questions at the end of the hypothetical that we want to hit on before we ask for final questions. And while you're sort of looking those over, I want to make sure everyone knows that we will be doing a part 2 of this discussion. And it'll only be an hour long, and it will be for creditors to talk about what creditors do and how creditors engage the system. Don and Alexandra?
Don, do you want me to pull that back up, or should I leave the chart on so that we can refer to it?
I think you can probably leave the chart.
Okay.
And I think we may have covered most of the remaining questions.
So.
I'm just looking at it now. Whether the business can afford to maintain both locations is one of the questions we had there. And maybe you can just touch on that one, Don, about how that would sort of be a question with regard to subchapter 5.
Yeah, I mean, I think it's it's definitely a good consideration. Obviously the TOB entered into this 5-year commercial lease. The fact that they're in arrears at this point, the landlord is probably poised to commence some sort of action against them anyway. The ability in the subchapter 5 to really 2 options. If they feel as though, you know what, we can make this location work. We've got the construction work is done. We're hoping that the tourist season starts to pick up a little bit. We can afford to operate this location. Well, in the subchapter 5, you get the opportunity to a reasonable period to cure that arrearage. And if the arrearage isn't so much so that it's insurmountable, it may be a way to sort of salvage that lease and continue to operate the business or start operating the business at that location. The other powerful tool is the ability to reject it. If the business decides that simply can't, afford to operate that location anymore, you can almost immediately eliminate the concern about having to continue to pay that lease by rejecting it through the subchapter 5. So
Alex, if you were representing the lessor, what would your perspective be?
You know, honestly, I'd rather have a negotiation in bankruptcy court than I would have to run to the courthouse to try and file an action to not only collect, but also to, you know, eject that business from the premises. That's a very complicated and involved and expensive undertaking. I'd rather be at the table negotiating in bankruptcy court where there's a trustee involved and where the business is going to make the right decision for them, and that we can amicably resolve things. And if it is that, you know, either they pay the arrearage off, which would be fantastic, or if not, they reject the lease and they move on with their life, and I can have my client move forward and release the property to someone else. So I think that is the preferred option, absolutely.
Did we leave anything out, Your Honor?
Well, and also just this concept, I think we've hit on it many times, but the second the bankruptcy is filed, the landlord is stopped in its tracks from doing anything. So the, you know, harassing phone calls about, you know, past due payments, or the, you know, fear that you're going to be brought into court and have to face the landlord in front of the superior court judge, it stops. And then you have time to really assess the situation and decide how you want to proceed.
And I think the other point, and I see this a lot, where I sometimes wonder why creditors want to have a bankruptcy case dismissed, because the creditors, for example, in this scenario, Alex's client, the lessor, you know, may decide that they're willing to enter into an agreement if the debtor pays X number of dollars per month toward this past due arrearage on the lease obligation. If the debtor misses it by 45 minutes, you know, Alex can be in bankruptcy court the next day. It won't be a surprise. The debtor will get notice and there'll be an opportunity to have a hearing. But the bankruptcy court is poised to operate, you know, much more quickly. Once a debtor and a creditor make an agreement, there's now the court essentially holding the debtor's feet to the fire. And, you know, as Alex said, if this has to go forward in state court, it's going to be a long and complex and expensive project.
Right, and uncertain. There's a level of certainty in bankruptcy court that you just don't have in other courts in the state. You just don't know what you're going to get in superior court. The judges change often, and there's different types of relief available. In bankruptcy court, we know who the judge is. We know what to expect. There are procedures for almost everything. So it's a very predictable forum.
Yeah.
I think we've covered all of the questions that were at the hypothetical, unless you have another, but we can.
I've got a couple more questions here. Clearly the first step for businesses is to have a meeting with a lawyer. Is there prep work that they should do to make that initial meeting more productive? And is there a set fee for that first meeting? Is there a free consultation? How does this work?
It's a great question. I mean, Don can speak to it probably better than I can. I would say that usually, you know, if someone was coming into my office to talk about a potential issue they were having, that would not be charged. It would be free of cost, and you know, you would just talk through your issues. But in terms of what documentation you need to provide, basically all your financial information, profit and loss statements. But Don can give some more detail on that.
Yeah, I mean, I think it's, you know, I often look at it as, you know, the initial consultation, and I think it's generally true. I can't speak for every bankruptcy practitioner, but I think it's generally true that many bankruptcy practitioners, if not all, are at least willing to consult with somebody. You know, there might be a time limit. I'll give you an hour, you know, of time to consult about it. And then, you know, we have to get on the clock if it's going to be more than that. But I think generally, you know, the bankruptcy bar is willing to accommodate. As far as what the business needs to do to prepare, I look at it generally as, you know, we should kind of pattern the same requirements that you would have to in terms of document production that you would need for the actual filing, right? So we want to look at balance sheets. We want to look at, you know, maybe some backstory, having the business owners give some detail as to the backstory, how they ended up in the position they're in, cash flow statements, tax returns to the extent that they've been filed, projection of your accounts receivable and your accounts payable. It's also great to have if the business has engaged in a budgeting process. It's also great to have some sense of actual versus projected to see maybe where the business might be missing the mark. But certainly your essential suite of financial statements, the profit and loss, the balance sheet, and then just a handle on your accounts receivable and accounts payable. And I think it's really the judge mentioned this, that loan to from Brother Bob or whatever. It's important for the debtors to walk in with the mindset of full disclosure. We as attorneys, bankruptcy practitioners, can really only provide effective guidance and effective assistance if we're fully informed. And having the business prepare for that meeting with the attorney is really critical. Taking the time to prepare the financial statements, to gather the bank statements, to gather the tax returns, and being prepared for that meeting is really critical. Which I know that was sort of a scattershot answer to the question.
Is it helpful, Don, for the attorney to get any of that information in advance of the meeting?
Yeah, I mean, it's always helpful to have the information ahead of time if possible. It's not always possible, but it is difficult to for an attorney to sit there and flip through 150-page tax return in the midst of a consultation. So I would say at a minimum, providing a profit and loss statement, providing the balance sheets, and then that general overview, that summation of what led the business to make the call in the first place to a bankruptcy attorney is, I would say, kind of the minimum stuff that we would need in advance of a consultation.
And the other piece I would add, just based on what I see, is if the business has any appraisals, those are extremely helpful because, as I said before, the cram down is a very powerful tool in bankruptcy, and it's all driven by the value of the asset. And if there is no appraisal, then perhaps the tax assessment for real estate and with the purchase price, for personal property, cars, boats, trains, whatever. Because unfortunately, probably like all humans, people who seek bankruptcy relief often think their assets are worth much more than the market would value them at. So realistic valuations going into the case can be essential. And I see that as the debtor's attorney's job, is to help the debtor get a more realistic view of what the business can do, what the assets are worth, and how viable a reorganization is. In my first job, I clerked for a bankruptcy judge who used to tell me all the time that the bankruptcy debtors all had terminal euphoria. They just thought it was going to work out no matter what. And, the lawyer needs to sort of bring them back down to earth. And probably the business consultants are doing that when they can as well.
Absolutely. So the final question I have here, and I think it's a great one to end on, is do the members of the panel see any additional complications because of COVID or additional assistance because of COVID? And look to the future and what you see and how things will, how you think they're going to turn out in the next few months.
Just in general?
I mean, I would say one of the benefits, just an easy answer on that one, is the accessibility to the court. And, all the hearings and meetings so far since COVID has started have been online. And it does make it a lot easier for debtors to appear. Vermont's a large state, and, they have to drive to Burlington and Rutland under normal circumstances. And COVID has allowed everyone to appear remotely, if hopefully your internet works well enough, but you can appear from your home, and that is helpful, I would say. There are lots of other things. I mean, subchapter 5 is really part of this whole concept of giving relief to small businesses because of the difficult economic realities that we're facing right now. So I would say that's another benefit, and it's here to stay. Whether or not the debt limit is extended, I don't know if the judge knows more on that than I do, but as of now, that $7 million debt limit is still in effect through March, and it may be extended. So that's another huge benefit.
Does that apply at the time of filing, or is that
Yes.
okay?
Yep. Those are just off the top of my head.
Yeah, and the other thing I think about COVID is it's a bit unpredictable, and I think people are waiting to see if, for example, the PPP loans are going to be available to debtors going forward. I mean, that was one of the provisions in the Consolidated Appropriations Act of 2021, was that the SBA administrator has the discretion to decide whether she's going to allow subchapter 5 debtors to actually get PPPs, because right now, if an entity is in bankruptcy, they're not eligible. And so that's one complication at the moment that we hope to have resolved fairly soon. On the other side of the equation, we have local rules in place that allow debtors to get a temporary waiver of the payments that are due under their plans if their inability to make the payments right now is COVID related. And there's provision to extend the term of Chapter 13 plans to 84 months instead of 60 months because of COVID. And there is actually a folder on the bankruptcy court's website that has all of these special types of relief that we've implemented in response to COVID. So if somebody's particularly interested in what impact it's had, you can find it there. And the other one that pops into my head is historically only attorneys were allowed to use digital signatures on documents, but anybody other than an attorney had to actually sign, and that was something that became much more complicated as a result of the isolation imposed by the pandemic. And so currently anyone can sign a document digitally using a particular double authentication version of digital signatures. So those are the things that I think COVID has brought to us.
One other thing that comes to mind that I might mention is the foreclosure moratorium that's in place in Vermont right now. The governor just extended the state of emergency through March 15th, 2021. And there's been legislation in the state that extends the moratorium for 30 days past the expiration of the governor's state of emergency. I fully suspect that the governor will extend it once more. At least I would say that I wouldn't expect it to be lifted anytime over the winter months. And so that is providing some relief to people that may come to an end at some point and may result in possibly more bankruptcies because foreclosures are going to commence once again.
Because those relief, certainly relief from eviction and other things, doesn't mean that you're relieved from paying. It just means that it postpones the eviction.
Exactly. Yeah, right. The obligation to pay is still there.
Exactly.
And that's where I think the subchapter 5, is really very timely in that, a lot of businesses, are perfectly, I think there's going to be, a lot of pent up capacity in the economy. And once things get back to some semblance of normalcy, who knows when that'll be. I think, the economy will hopefully start chugging along. And, for many businesses who have felt a crunch due to COVID, this reorganization process through a subchapter 5, for example, may be the thing that, allows them to weather the storm. The one thing, that I think, and we've hit it a number of times, so I apologize for kind of repeating the concept, but, this idea of the plan, allows you to plan for a future that the business can actually afford, not necessarily the future that the business is stuck with based on its current obligations. So I think that's a really, when a business looks at trying to emerge from this era of COVID, the idea of kind of planning for a future that the business can actually afford and sustain is really, is really going to be critical.
Those are great points. Alexandra, may I ask you to put the last couple of slides back up for places where folks can find this presentation
Yes.
afterwards? Thank the panelists so much for all the hard work you put in on this. It's been a great experience, and working with you has been wonderful, as well as the information you've shared is so critical right now. So thank you.